The same one. All right. Don't run away, everybody. Don't run away. We have another guy coming up. It's going to be real fun. He's going to talk about stumbling out of a saloon, intoxication, and impairment. We have Charlie Drummond. He's the founder of Professional Insurance Defense. It's a insurance defense firm based out of Birmingham, Alabama, that focuses on defending employers and insurers and workers' compensation cases in the circuit and appeal courts of Alabama. Charlie has specialized experience representing clients involved in complex multi-party litigation where workers' compensation carriers' rights to reimbursement are at stake. This is fun stuff, you guys. So Charlie also is experienced in litigating occupational accident policy, owner-controlled insurance policy, and insurance coverage disputes. Charlie has extensive experience working in the automobile manufacturing, interstate trucking, food processing, construction, and mining industries, which gives him a unique perspective when representing his clients. A portion of Charlie's practice is devoted to serving outside counsel to several large corporations in Alabama. Outside of work, Charlie enjoys spending time with his two sons, Will, who is 11, and Jet, who's 2, and performing volunteer work with Muscular Dystrophy Association of Alabama. Will y'all help me welcome Charlie Drummond up here to talk about his interesting topic. Thank you, Charlie.
Thank you, Haley.
You're welcome.
Hey, for anybody who doesn't know, really quick, Haley, before you sit down, Matt was talking about a while ago how, over the years, we've kind of all become a big family. So I would like for the family to congratulate Miss Key here and her fiance, Dustin Watkins. Dustin, are you in here?
Probably not.
Probably not. He's
breaking down his booth.
Probably so. So Haley and Dustin are getting married in a few days. So and you guys met through work, basically, right?
We did. We actually, I'm glad you're bringing this up. It's the first time everybody's made me do this. We met at a workers' comp conference on Valentine's Day at Winter Asia 4 years ago.
4 years already.
Yes,
wow.
Yes.
And you guys are getting married the 25th, right?
The 25th.
Somewhere on the beach.
Workers' comp had made a marriage happen.
Exactly. It's definitely made a lot of divorces happen, so I'm glad it's finally made a marriage happen.
We're not going to have that happen.
Congrats.
I'm going to break that trend.
Haley.
Thank you.
And congrats, Dustin. Well, good morning, everybody. I'm so glad to see we got a huge turnout. I was going to ask, am I the only one who, when it gets this time of year and the time is about to change, and you wake up and it's still dark for like an hour and a half after you get up, am I the only one that struggles with that? I went to wake up my kids this morning. Huh? Is that the clicker? Yeah, I definitely need the clicker. Whoa, there's a bright light there. I feel like I'm about to get tested for intoxication and impairment staring into that light. I go to wake up my kids this morning, and like Haley said, I've got an 11-year-old and a 2-year-old, and I walk in my 2-year-old's room, and I'm like, come on, buddy, it's time to get up. You got to go to school. Daddy's got to go to work. He's like, no, Dada, it's still night time, not for working, night time for sweeping. He says sweeping. He hasn't mastered the L yet, and I was like, well, buddy, sweeping is going to be Daddy's working if we don't get here on time today. So you got to get up. And then, so it's still dark when we pull out of the neighborhood. I mean, like, we round the corner and there's a long stretch of road, actually between mine and Haley's mother's house. Haley's mother, Barbara, you probably know, she's actually one of my neighbors. So we're on this long stretch of road, and there's a deer right in the middle of the road. Still dark. I expect it to kind of move out of the way as we pull up, but we get right up on it. It's still just there, right in the middle of the road. And I look, and this deer has no eyes. Like, what do you even call a deer with no eyes? Because I have no idea. I honked the horn, and it still didn't move. But I looked, it didn't even have legs. You know what you call a deer with no eyes and no legs? Still no idea. All right, so today we're going to talk about intoxication and impairment. Apparently I'm the expert from experience on those things, they figured. So who better to talk about that, right? So I called this stumbling out of the saloon. I started to include in the title Stumbling into the Saloon because some of this topic's really interesting. Some of it's, a little dry. And so I'm probably going to kind of intersperse some cowboy saloon jokes along the way that are probably better than my deer jokes. But, hopefully kind of what we're going to kind of cover is, what are these defenses? Where do they come from? How do you use them from a practical standpoint? And when you have a suspicion that somebody's been hurt on the job and they're either high or stoned or drunk, well, how do you set up that claim to give yourself the best chances to prevail on these defenses? Wrong button. So where do these defenses come from? Well, 25.551 section of the Workers' Comp Act basically says that no compensation is allowed for any injury that is brought on by an accident due to the employee's own impairment or intoxication. Now, the employer has the burden of proving this. This isn't one of these things to where you have a positive drug test and end of story. Far, far, far from the case. These are not easy cases to prevail on, but hopefully, you can set yourself up to give yourself the best chance. The burden of proof is on the employer. The employer has to prove two different things. They got to first of all prove that the employee was actually intoxicated or impaired. That's the first thing. That alone is still not going to get you there. You also have to prove as the employer that the intoxication or the impairment was the proximate cause of the accident and injury. And we'll talk about that a little bit more in a minute. So the first thing you want to look at is, well, how do I prove that somebody's intoxicated or impaired? Well, there's a couple of different ways. The one that a lot of you are probably already familiar with is what we call the conclusive presumption, and we'll talk about that in a minute. But that's not the only way in Alabama that you can prove that somebody was intoxicated or impaired at the time of the accident. You can take circumstantial evidence. You may have witnesses that witnessed the employee stumbling around drunk before the accident. You may have co-employees or friends of the claimant from outside of work who were there when he was smoking the joints right before he walked in the front door. You may have a drug test that, while it is a valid drug test, for whatever reason does not fall under what we're going to talk about with a conclusive presumption, which is a DOT test. Those are all ways that you can prove impairment or intoxication. You don't necessarily have to have what's called a DOT compliant drug test that says somebody was impaired. It definitely helps because also within 25.551, we have this language that says if you've got a positive drug test and that drug test was conducted and evaluated, both conducted and evaluated, not one, not the other, both. It's got to be conducted and evaluated in accordance with United States Department of Transportation standards, then you have a conclusive presumption that the employee was impaired from the use of illegal drugs. Now, this doesn't apply to intoxication. Alcohol, totally different thing. We're going to talk about that in a minute because there is no DOT compliant alcohol test. In terms of it's when you're looking at the conclusive presumption, it's talking about illegal drugs. Now, can you deny a claim or prevail on a claim because there's a alcohol test that tests positive? Well, yes, but it's a little bit different the way it works. So, first of all, why do we use DOT? Why do we use DOT standards? Well, the DOT back in the late 80s, early 90s, basically said, we want to kind of standardize the way that we're keeping drunk employees off the roads that are driving trucks. And keep in mind, the DOT, they cover everything. If it moves by road, if it moves by rail, if it moves by ship, if it moves by air, the DOT has some involvement in it. And they're like, we want to make sure that when things are being moved around this country, the people doing the moving or they're involved in what they call safety-sensitive functions are not, they're not drunk, they're not high, they're not impaired in any way. It's for the general safety of the public. We need some sort of standard in place, because up to that point, believe it or not, prior to the late 80s and when they actually passed the law in 1991, there was no universal standard. And say like the state of Alabama, for instance, does not have a universal standard. But what the Alabama legislature did is they adopted the DOT standards, because those had been in place now for the last 30 plus years, and they're very comprehensive, and they cover a wide range of people, because it's not just truck drivers, it's not just the guy that's conducting the train or driving the train. It's anybody in any kind of function where their job directly impacts the safety of moving those things around. And so a lot of it, why Alabama adopted the DOT standards, was really because they've been in place for a long time, and they've actually gone through and figured out, well, what is the best way to test for drugs? What's the best way to evaluate a drug test? And they've created quite the laundry list of requirements. So a lot of it was, why reinvent the wheel? Let's just use what's already in place. So because of that, when they adopted this in 25-551 as our standard for determining whether somebody's intoxicated or impaired, under Alabama workers' compensation law, they said, we want to make it to where if you follow those federal standards, those DOT standards, you have what is called a conclusive presumption that the person was impaired. And what does that mean? Well, a conclusive presumption is something that, because of certain proven facts, the law says if these facts are proven, you must find that this other presumed fact is also true. That you can't rebut this with any other evidence. If you have a DOT compliant drug test, it doesn't matter if you have an employee that witnessed the guy the morning of, and hey, he was acting fine, he wasn't stumbling around, he was talking clearly, he was doing all these things that somebody that was high wouldn't be able to do. It doesn't matter. If you have a DOT compliant drug test, there is an absolute presumption that they are impaired. Now that's if you have the compliant drug test. We'll talk about that in a minute. Basically, it's a presumption law that cannot be rebutted by other evidence. Now, what if they refuse a drug test? Well, if you're the employer and you're doing what you should be before you actually have, send them to get tested, you're going to provide them with something in writing that says this right here. It says that you understand that if you refuse to take our drug test, you forfeit your right to compensation. You give them that. If they refuse it, you don't have to pay them. Now, we're going to talk a little bit in a minute about whether this applies to medical benefits too, but compensation is generally what's considered the money part of a claim. And for the most part, we're going to see that even if you have an intoxication or impairment defense, it doesn't necessarily relieve you of your liability for medical benefits. So, again, the DOT, they've set up standards going back to that 1991 law that says we're going to spell out rules on how the sample must be collected, how it must be tested, and how it must be evaluated or reviewed, okay? And all this is contained in the Code of Federal Regulations. I thought I was going to be really cool and high-tech and say, you know what if somebody wants to look up what all these regulations are? I could put a website link up there, but it was about, one of these links about this long, so I'm like, I'm not going to do that. I'm going to make it a QR code. I was so proud of myself, because anybody who knows me knows I'm not a tech-savvy person. So I made this QR code that will, if you take a picture of it or you put your phone up to it, it will take you to a website that essentially says, ha ha, we stole $20 of Charlie's money. So it worked until yesterday, But we have to turn in these presentations a couple weeks early, and apparently it was only a 2-week trial. So what I have done is, if you go to my firm's Facebook page, if you just on Facebook go to Professional Insurance Defense, there is a link to what that QR code was supposed to take you to, which is all the DOT standards that cover collection, testing, and evaluation. So when we talk about the testing part, what are we even testing for when we do a drug test? Well, what drugs are tested, what levels of those drugs constitutes an impairment, how is the urine test that they actually collect the specimen with administered, and then what about things that are like prescription drugs? Let's say you've got somebody that tests positive for opiates, but they've got a prescription for Opana or some sort of opioid narcotic medication. They have a legit prescription. So we're going to talk about that. As far as what they test, obviously they're going to test for marijuana. Specifically, they're testing for THC, which is the chemical in marijuana that gives you all the good stuff. You've got cocaine. You got opiates, heroin, morphine, codeine. You've got PCP, you got amphetamines, which also includes MDMA or Molly, and those are the only things they're testing for. Notably absent from this, things like LSD, that some of the new drugs like Spice, they're not tested for. You're not going to find a DOT-compliant drug test where somebody tests positive for LSD. So if you've got somebody who gets hurt on the job because they're tripping balls on acid, you're going to have to prove it some other way. It's not going to be a DOT-compliant test, and you're not going to get the conclusive presumption. What about prescription drugs? So when it comes to safety-sensitive DOT functions, this is primarily if you've got truck driver claims. I do a lot of truck driver claims. Well, if they test positive for a prescription drug that could impair their function, well, is that impairment from an illegal drug? Well, first of all, do they have a prescription for it? If so, then we go on, well, are certain minimum standards in place? We look at, is that medicine actually prescribed by a licensed physician? All right, if it is has that physician made a good faith judgment that he knows what that employee, what his job entails, and has he made a good faith judgment that he can take that prescription medication and safely perform his job? Is the prescription drug, is it being used at the prescribed dosage? Because obviously, just because you have a prescription, you can overtake anything and can render you impaired. If the employee is being treated by more than one physician, basically for a prescription drug to be legal for a safety-sensitive function like a truck driver, basically at least one of the physicians he's seeing has to be aware that he's seeing other doctors and be aware of every drug that those other doctors are prescribing. And at least one of them has to know all this information and still say, well, at the prescribed levels, knowing all this, it's still safe for this guy to be carrying out a safety-sensitive function. And then there are some prescription drugs, and there's a list of them if you follow that link that we talked about a while ago. There are some drugs that, no matter what, they're just specifically prohibited by based on their position on the FDA's schedule of controlled substances that are never legal for safety-sensitive functions for truck drivers. You're really looking at stuff like fentanyl. If you got a truck driver that's on fentanyl, it doesn't matter what his doctors know, he's not supposed to be driving a truck on fentanyl. And that is, if you get a drug test that shows he's got fentanyl, that is an illegal drug for purposes of this defense. Some things that are not going to show up, though. I've had a lot of calls over the last couple of years about, well, I had a claimant, Charlie, and he tested positive for THC, but he says he used some CBD oil, or he smoked some Delta 8, or ate some Delta 8 gummies. Well, a test is not going to differentiate between spice, CBD, Delta 8, those kind of drugs that have THC in them. The test isn't going to tell you, did they smoke a joint, did they eat a gummy. It's also not going to tell you, did they actually smoke marijuana, or did they smoke Delta 8, or did they eat a pot brownie, or did they take a Delta 8 gummy. But it's also not a defense that's their explanation for it. And we're going to talk about, there are some instances where when you're evaluating the test, there's going to be a time for explaining some errant results, but this isn't one of them. Whether it's Delta 8 or a big fat blunt, if they test positive for THC, they're positive for THC. Doesn't matter where it came from. So there's a lot. Again, if you follow the link on the Facebook page I directed to you, it's going to give you a lot of stuff. It's going to give you a lot more information than you want. I kind of hit the highlights on the slide, but honestly, I'm not going to stand up here and read the slide to you. I figured this is a good place for a cowboy joke while I just kind of keep a few slides on the screen. So there's a cowboy, and one day he stumbles into a bar. And I mean, he is just staggeringly drunk. And he just comes, wobbling all up in there, straight up to the bartender. Barkeep, I need a shot of whiskey. The barkeep says, cowboy, you're not getting a shot of whiskey. You're already drunk. You got to get out of here. I can't serve you. So he's ticked off, but he stumbles out. About 10 minutes later, same cowboy goes stumbling through the back door of the saloon. Again, bartender, I need a shot of whiskey. I already told you, you're too drunk. Get out of here. I can't serve you. Well, 5-10 minutes later, here comes cowboy again, back through the front doors of the saloon. And I mean, he's literally just doing all he can do to even stand up, crashes into the bar, is like, I need another shot of whiskey. Bartender says, I already told you, you're too drunk to serve. I'm not giving you any whiskey. And he's like, how many friggin' bars do you work at around here? Again, when we talk about collection, there's specific procedures in place. What I didn't know until I was preparing for this, and what a lot of you may not know, they actually have to get, they split the specimen that they take. Let me back up. So first of all, a DOT-compliant drug test is always a urine test. Last year, about this time last year, the DOT looked at possibly changing the rules to allow things like blood tests for drugs. And they actually shot it down. They said, well, we don't really have any information showing that a blood test is or is not more reliable than a urine test. So the only DOT-compliant drug test is going to be a urine test. And what I didn't know is that when they take the urine sample, they actually have to split it into two different containers. They have to get at least 45 milliliters of urine, and they have to split it in what they call an A container and a B container. And that's used, they don't test the B, they seal it. When they seal the A, they seal the B, and they don't test the B right away. That's for a confirmation down the road since you've got another sample. Some highlights here, though, basically there's the container they're going to be taking the sample in. It's supposed to be sealed until it's open in the employee's presence. That's to keep the employee obviously from saying, well, somebody tampered with it. You've got the two bottles, the A bottle and the B bottle. There's some paperwork in place that's necessary for maintaining the chain of custody, and that may come into play later on too. When they come to testing, there's an automatic retest. A lot of people don't know this. If the first test is positive, there's an automatic retest. It's not reported to, if it's your claim, it's not going to be reported to you as the employer or the insurer based on just one positive test. It's actually two. If you're getting a positive test, it's actually been tested twice if it's DOT compliant. They have to store it for at least 12 months. Okay, so your question is, if the first test is positive and then so there's not a retaking. It's not a resampling. It's them testing the same sample twice. In other words, they're not having the guy pee in the cup again.
Right.
It's not that.
Once he's peed in the cup and he comes back inconclusive, and he refuses to do the second test, you can't really deny it for him not being compliant if he won't first.
Well, the statute says if they've been warned that they refuse, they won't be entitled to compensation. There's no case law in there that says, well, you can only ask them one time. The statute doesn't say you can only ask them one time. Now, with that said, how much time is going by? Because it doesn't really do you any good if a lot of time's gone by. So I guess, in other words, how much time's gone by between the first test that they took? Well, maybe not. They do have procedures, and we're going to talk about those in a minute. They do have procedures that say, look, if the result's inconclusive, then what does the MRO, the medical review officer, do? But to answer your question, well, can you deny it if they refuse the second time? I haven't seen anything that says you can't. And I'm always of the opinion, if nobody's told me I can't do it, I'm going to do it. Seriously, though, there is no case law on it. And the statute doesn't say you can only test them once. So what are they testing for? We talked about what they're testing for. What are the amounts they're testing? Well, here is a table that shows what the cutoff is, what constitutes a positive drug test or a DOT, and all you really need to know out of this is these are very, very, very small amounts. Basically, the goal of a DOT test is it's not to say, well, there's any way, they would have to be impaired at this level. Basically, these are very small amounts. If there's any in the system and it picks up, you still get the conclusive presumption of impairment, even though there's small amounts of these drugs, if you've followed all the procedures. I want to go back. I actually switched sides and got a question, but I was talking about the fact that they have to maintain the sample for at least 12 months. And this is a really big deal. I didn't know how big of a deal it was until a few years ago. I had a case where we had a positive cocaine result on a guy who fell off a loading dock. His injuries ended up being fatal. He had cocaine in his system, and the hospital was telling us, well, we're not releasing a sample to you, and in fact, we're about to throw it out. And we're like, well, what do you mean you're about to throw it out? It's only been like a month and a half. They're like, no, yeah, we don't keep them. Well, that's a big red flag, because you know what? If they don't keep them for 12 months, it ain't a DOT compliant test. Now, you look at their drug test, and it says it's a DOT compliant test, but guess what? If I'm a plaintiff's attorney and I see that they kept that sample for a month and a half and then tossed it versus 12 months, it is not a DOT compliant test, because compliance means absolute compliance. So that's why all these collection procedures, all these testing procedures, all this is important. And something I learned is, and this is not across the board, and I tried to actually poll hospitals around Alabama to find out who would tell me and who would tell me whether their test was DOT compliant and who wouldn't. But one thing I have found in my personal experience is generally the bigger the hospital, the less likely it is they're going to follow DOT procedures. I'm not going to name any hospitals specifically because we probably have some representatives here from some of these hospitals, but you would be surprised at this fact. But I think a lot of it is because how many drug tests a day does the largest hospital in Birmingham, Alabama do? And can you imagine keeping all those samples for 12 months? What size building would you need to store them in? So that brings up an important thing. If you really think there's drugs to blame, you might want to look at doing an independent test at a lab versus just relying on what they do in the ER, bottom line. All right, so we got the results. The MRO, medical resource officer is going to, he's going to review everything. He's going to review all the paperwork. And If it's positive, adulterated, or a substituted test, then they're going to conduct an interview with the employee to determine whether there's a legitimate medical reason for the result. The MRO, another very critical part, and another place where what looks like a DOT compliant test turns into not being one, is the MRO has to tell the employee that he or she has 72 hours to request that the B bottle, the one that's still sealed, be sent off to a certified lab and tested. That's why it's kept around. So what about alcohol? It's a lot simpler, a whole lot simpler than drug testing. There's not all these procedures. I mean, there's some procedures, but it's not nearly as intense. Basically, everybody knows the legal limit in Alabama to drive a vehicle on the road, if you're just me or you or anybody in this room, is 0.8. I'm sorry, 0.08. 0.08% blood alcohol content is going to be intoxicated. That's not the case when it comes to the standards for a workplace injury. It's actually 0.02. It's hardly any alcohol in the system at all. Realistically, if you took a little bit too much of certain cough medicines and you don't weigh a lot, you can get to that on one dose. But there is a procedure. Basically, and it's also a double test to some extent. If it's a positive, well, a different person may have to do the second test, because the first go around you can have a screening test technician do it, or you can have a breath alcohol technician do the first test. But if it's positive, the blood alcohol technician has to do the confirmation test. Again, we've got a lot of really in-depth procedures here, not nearly as much as for drug tests, but basically it's just a breath test. And they're looking for anything that's 0.02 or higher. If it is, they're going to call it a positive test. Between a positive breath, between the first breath positive and the second one, they got to wait at least 15 minutes, but no more than 30 minutes before doing the second one, the confirmation test with the BAT, if it was done with the other technician to begin with. They got to use a new mouthpiece too. So that's basically, if you're going to establish, if you're wanting the conclusive presumption. In other words, if you don't want to have to prove intoxication or impairment by some other method, if you don't want to have to if you don't have witnesses to come in there and testify, you don't have another drug test, but you have the DOT, you're halfway home. If you have that DOT compliant test, and it's truly DOT compliant, because I can tell you, if for a little while, a lot of y'all may not know this, for a little while before I was a work comp defense lawyer, I actually did some plaintiff's work, and I actually had a guy who tested positive for marijuana at the time he got hurt on the job. And what I did is, I attacked the credibility of the MRO that certified as a DOT compliant test. Dug out all these procedures. I went through them, and as soon as I got him to say no to, did you do this, do that, a few times, I knew I was home free. But but if you have that in place, you're still not home free. You're halfway there. You got to prove it, and I say halfway in terms of you got to prove two things, but really you're only about a fourth of the way there, because the hardest thing to prove is proximate cause. In Alabama, the general rule is proximate cause means an act is the proximate cause of an injury if it's the direct and natural consequence would be, well, if you do this, an accident is going to happen, or more likely to happen, most likely going to happen. In other words, if you got a guy walking across the room, let's say I'm walking and this big old chandelier falls on me and somehow doesn't kill me. It hurts me really bad. The chandelier falls right on my head. And let's just say that I'm high. Me being high has nothing to do with that injury. There is no way in hell my employer, if I had one, could say my intoxication or impairment was the proximate cause of my injury, unless it fell really, really slowly, and I would have had time to get out of its way. But that's a pretty big chandelier. That's why I use it as an example. It's a big old chandelier. I'm not going to avoid that whether I'm high or whether I'm completely sober. So proximate cause is the most important thing and the most challenging thing to prove. So what is proximate cause and what isn't? And I think the best way to look at this is through the case law, so you can kind of see some examples. So we got the case of Ross versus Eller Construction. Ross's finger got cut off in a work-related accident, probably a mousetrap. He was taken to the hospital. He was given a DOT-compliant drug test, showing he had drugs in his system. He still sued his employer, and as soon as he sued, his employer filed suit and said, look, he had a positive drug test, DOT-compliant, end of story, we're not paying this guy a dime. The trial court actually granted that motion for summary judgment, ruled in the employer's favor. Now, I got to check the time real quick, make sure I'm not going too long. All right. Actually ruled in the employer's favor, but the employee appealed, and the employers, basically the employee said, well, okay, fine, if I was impaired, that didn't prove that had anything to do with my accident or my injury. Well, the employer said, well, the conclusive presumption, if you read 25-551, it looks like it says all you have to do is show they were impaired for a DOT test. 25-551 doesn't really say anything about having to prove probable cause, and the legislature obviously intended to make it just a per se exclusion of workers' comp benefits if you've got a DOT-compliant test. The Court of Appeals said no. That conclusive presumption doesn't apply to the cause of the accident. You only get a presumption they're impaired. It's up to you to prove that the impairment caused the accident, the injury. So they reversed and remanded. There was material facts as to what really went on. It was summary judgment. It definitely wasn't a summary judgment issue, and realistically they wouldn't have been able to get it through in trial. We also have Parker Hannafin Court versus Harrell. Harrell hurt his back turning a wrench on a machine. Basically, the bolt suddenly broke loose. He felt a jerk in his arm. They tested him for drugs, and he did. He tested positive for pot. So, despite that, that's really all they did. They just proved he was high. Trial court found in the employee's favor. It's like, you just found he was high. Proved he was high. You didn't really prove anything else. But they appealed. The employer appealed. They said, we're entitled to the presumption that he's impaired because it was a DOT-compliant test, but the substantial evidence said that him being high really didn't have anything to do with the bolt breaking loose, which was really what caused the injury. So they ruled in favor of the employee in that one. We've got Flower Specialty Foods of Montgomery versus Glenn. Glenn was working on a machine called a pan stacker. Something got jammed. He tried to climb up in it to fix it. When he did, he had on Flowers, the bread company, and he has on like a baking mitt. He gets caught in the sprocket, pulls his hand in there, cuts off a finger and some stuff, and he tests positive for marijuana. There was a lot of witness testimony that said, okay, fine, he tested positive for marijuana, but even his boss said, he seemed fine that day. We don't think he was impaired. And so this is the evidence that Glenn puts on at trial, look, I've got all these witnesses that I was not impaired. There was no evidence he was unable to do his job. There was no evidence he was lethargic. All they really had on him was a DOT-compliant drug screen that was positive.
I did find a supervisor that said, yeah, he was high all day, I just let him keep working.
Do I now?
I
Oh yeah, no, they're never going to say that. Yeah, they're never going to admit to it. Then their butt's on the line, right? So in Glenn, the trial court found that he was impaired as a matter of law. But they also found that his injury was really caused by his baking mitt getting hung in the sprocket, which didn't have a chain guard, and said that the bakery failed to meet its burden of proof as to proximate cause. The Court of Appeals basically looked at it and said, we're not going to reweigh the evidence. That's not our job. We're not going to reweigh the evidence. There's enough facts in the evidence to support that finding, so we're just going to leave it. And that's where it stayed. Now we got Collins Signs versus Smith. Smith was moving a sign on a dolly. Somehow the sign fell on him. There was some testimony about the guy who was helping him move it maybe dropped his end or didn't help keep it from falling on him. But it hit his shoulder. It knocked him down. He had marijuana in his system. He even admitted, look, if I would have been high, or if I would have known it was falling, I could have gotten out of its way. The employer said, well, look, there's all this evidence that even a little bit of marijuana can slow your reaction time and all that. The trial court said that Smith's impairment was a contributing cause of the accident, but it wasn't the sole cause of the accident, so they actually awarded him benefits. The employer appealed. 1 minute. I got 1 minute. All right. Basically, they said, look, it doesn't have to be the sole cause. The impairment, you don't have to prove the impairment was the sole cause. If it's a contributing cause, it's going to be the proximate cause. I'm getting the gong, so I will leave you guys with that. If anybody's got any questions, we're about to take a break, so find me out there. Thank you all so much for having me. And
She had a question over there.
go ahead.
Don't leave yet, please.
Like if you have a workplace accident, is there anything against requiring a drug test?
The answer is no. Now, a few years ago, that answer was a little bit more convoluted because during the beginning of the Obama administration, which administers the DOT or oversees the DOT, it's an executive branch, the DOT came out and said, we don't want you drug testing people just because they have an accident. There's got to be some sort of rational link between the accident and the fact that drugs could have caused it. That has since been rescinded. I know there was a major change made to it in 2018 that basically where they clarified OSHA's not saying that you can't drug test. These are things. My understanding is that right around 2020, it was kind of strengthened again back to how it existed prior to 2016. But to my knowledge, the current administration has not tweaked it any further. So yes, you can drug test basically anybody that has an accident. All right.
We have a break until 10:30, correct? 10:30? All right.
Yeah, I need to make a quick announcement, please. I had said the back table. It turns out there's not a back table. So this is now the almost back table. So if you are an adjuster, please come fill out your form. And when you are done, please put it in the bag. This is AWCO. Otherwise, no credits.
Test, test, test.